Important topic, that what should be the steps which we executive as G or AG should take during the arbitration. There is a huge list of issues, but I have tried to summarize very limited points which could be decisive, which could be very important in turning the decision of arbitral tribunal in favor of Union of India. The first issue is the appointment of arbitrator. Condition 70 of 2249 very clearly says that the arbitrator should be an engineer. If any court is appointing the arbitrator as a retired judge, then it can be challenged in court of law. Second, there was a recent judgment by Honorable Supreme Court of India in Perkins Eastman Architect DPC versus HSCCC. Very landmark judgment in the history of arbitration in India, where Honorable Supreme Court in November 19, they have said that any party which has interest in the outcome of the arbitration cannot unilaterally appoint the arbitrator. This is a watershed judgment in the history of arbitration. Why? Because in our department we have a practice of appointing the arbitrator from the department. It is still continued. However, after this judgment, if the contractor or the other party puts this appointment of arbitrator into dispute, then such appointment of arbitrator becomes null and void. No party which has interest in the outcome of arbitration can unilaterally appoint the arbitrator. It is only the effect of this judgment that headquarter MES has come up with the formulation of panel of arbitrators, which is a panel of retired officers, and now the important arbitration disputes will have the arbitrators selected or appointed out of that independent panel. The next point is very important. In fact, the most important point in this entire discussion. This is the establishing the identity of the private party. We MES represent sovereign, we represent state, but what about the other party? It is often seen that if the Union of India wins an arbitration case, the party against runs away and it is not traceable. So I would suggest everyone that before you enter into the arbitration proceedings, ask from the another party, private party, to establish their identity, establish their assets, ask for their PAN card, ask for their functional current bank account details, see what is the nature of firm, whether it is sole proprietorship, whether it is a partnership, whether it is a company. If it is a sole proprietorship, it need not to be registered anywhere. Sole proprietorships are covered under Trade and Establishment Act of the respective states. They need not be registered. The liability of the firm and liability of the individual are one and the same thing. You can get the accounts of the individual also attached. However, it is not true for the company. Companies Act 2013 says that the company, the firm and the individual are two separate identities. You must have legal representative in front of you as authorized from the company board. Board of the company must nominate their legal representative to the arbitral tribunal. It is important because if the case doesn't go into their favor, then section 34 there is a clause that party was under some incapacity and this becomes a ground. The same contractor would say that somebody else went to the arbitral proceedings and it was not their legal representative, and if they prove so, the entire arbitral award can be set aside, and despite the Union of India winning, we will be landing nowhere and again we will be starting from the scratch. So it is very important to establish the identity of the party. You have to enforce this, you have to push this. You can ask the arbitral tribunal under section 17 as the interim measure by the arbitral tribunal to ask the party to establish their identity, to establish their PAN card, functional bank account, and if the tribunal is not listening, then please approach courts under section 9, interim measures by court. They have to establish the identity of the party, otherwise if Union of India wins, then we fail to extract or we fail to enjoy the fruits of the arbitration award. The third step during the arbitration proceeding is to decide the admissibility of the claim. As I said, condition 70 of 2249 establishes very clearly that any such dispute where the decision by CWE or the accepting officer or any other officer is final and binding, in such a scenario that claim is not admissible. For example, condition 52 where the contract can be cancelled on the grounds of corrupt act. So such claims you have to finalize and sort out that they are whether admissible or not. Are you going to argue in the arbitration proceedings or not? For example, anything which has happened before the date of entering into or the contract coming into force as per section 7 as I discussed. So these are non-admissible. We must not waste our time in formulating pleading in defense. We can straight away say that these claims are non-admissible. Arbitration tribunal has to abide by that, provided it does not invoke section 18 competence of the arbitration tribunal. Then next point is to establish the sanctity of the evidence. Quite often it is seen that the contractors put false letters, false correspondence, false wage receipts, false gate passes, false royalty receipts in their statement of claims. As per section 101 of Indian Evidence Act 1872, it says that any party which is putting the evidence and wants to enjoy the benefit of that evidence must prove the sanctity of that evidence, and the burden of proof lies with that party. Section 101 Indian Evidence Act 1872. However, when I say so, the another party, the contractor party, can say that the Indian Evidence Act is not applicable in Indian Arbitration and Conciliation Act. However, I would like to invite your attention on section 19 of Indian Arbitration and Conciliation Act, which although it says that arbitral tribunal is not bounded by CPC, Code of Civil Procedure, or the Indian Evidence Act, but in the same section 19 in subsection 4 it says the power of the arbitral tribunal under subsection includes the power to determine the admissibility, relevance, material and weight of any evidence. It is very, very important. Although the Indian Evidence Act is not strictly applicable, but this particular line puts a great responsibility upon the tribunal to look into each and every evidence from the viewpoint of its admissibility, relevance, materiality and weight. If the evidence put forward does not satisfy all these parameters, it needs to be set aside. It cannot be relied upon. So please look into all the documents, all the correspondence which you have in your file and see very, very keenly that there is no false evidence or no evidence which is not corroborated or which has not been explained properly or not vetted by any third party or not documented properly cannot become a ground for the arbitral award.